Shalom. My name is Yofi Tirosh, and I'm a Tel Aviv University legal scholar and a human rights activist. In celebrating 100 years to the 19th Amendment, I would like to suggest some lines of commonality between women's historic battle over the right to vote and a current struggle by ultra-Orthodox women in Israel to run for office within ultra-Orthodox parties, a struggle with no end in sight. I recently delivered this talk in Hebrew on a panel organized by the Tel Aviv University's American Studies program and its NCJW Women and Gender Studies program. I am grateful to Rina Bennett for translating and encouraging me to deliver it in English. This talk is entitled Between Seneca Falls and Jerusalem, 21st Century Israeli Suffragism. The short time available to me would not allow me to do justice to the ultra-Orthodox women's struggle to be allowed to present themselves for office in ultra-Orthodox parties. Unfortunately, there are no resources in English on this affair yet, but a manuscript underway by researcher and activist Esti Rieder-Indursky compares the journey, their journey with the fight for women's suffrage. Alongside other brave women such as Tali Farkash, Esti Biton-Shushan, Michal Chernovitsky, Racheli Roshgold, and Racheli Ibenboim, Rieder is one of the founders of No Voice, No Vote, an initiative that fought or is fighting to create representation of ultra-Orthodox women in their ultra-Orthodox political parties, and her forthcoming account is worth looking out for. From a legal standpoint, the struggle of ultra-Orthodox women to be elected reached its peak in early 2019, when Israel's High Court of Justice ruled on two petitions. The first against the ultra-Orthodox Ashkenazi party, Yehadut HaTorah, and its refusal to include women on its list. The petition was filed by a secular attorney, Tami Ben-Porat, in conjunction with 10 women's organizations, while ultra-Orthodox female activists supported from the backbenches. The court asked the party representatives whether they would agree to remove the explicit stipulation found in the party's bylaws that men, but not women, could register as members. The party replied to the court that they had no problem with changing the wording. However, they were quick to clarify frankly that such a change in the bylaws wording would not lead to an actual change in admission of women to the party, as every party member must accept the authority of Gdolei HaTorah, the rabbis spiritually guiding the party, whose point-blank rejection of the possibility of women as political leaders is not negotiable. The court was satisfied with the technical change, and although it added that its doors were open to future petitions on the subject, it did not outline what facts would have to be brought before the court in order to establish a legal ground that would justify relief. The second petition was filed by activist Ruth Kolyan against Shas, the ultra-Orthodox Sephardic party, represented by the Rachman Center for the Advancement of Women. Here, Shas clarified that its bylaws contained no official prohibition on women being elected, hence the justices waived the petition as moot. Indeed, in the 3 elections since these rulings, and we've had frequent elections in Israel, no woman has been presented for elections despite active attempts by activists. In the late 1980s, the Supreme Court demonstrated greater vision and determination in addressing a similar issue. In response to a petition by Leah Shakdiel, who sought to serve on the religious council in a small southern municipality of Yerucham, Justice Menachem Eilon, a religious justice and a renowned scholar of Jewish halacha, politely rejected threats by the chief rabbinate that they would boycott religious councils that included women. In Israel, he wrote, women participate in positions of leadership. This follows from the right to equality, period. The picture emerging from comparing the past and present struggles is both disheartening and encouraging. Disheartening in that the means of suppressing women's struggle for equality and participation remain so similar despite the passage of time. But encouraging because, like with women's suffrage, I have no doubt that folks in 100 years would not be able to understand what was so challenging and controversial with the claim that democratic systems could not let parties participate in the political process if they categorically excluded women. Here then are some similarities between the two struggles. Both then and now, women's demands to enter spaces of participation that were previously closed to them have been regarded as dangerous and unnatural deviation from the gendered order. Those opposing women's rights for political participation frame its advocates as masculine, witches or demons, undermining their womanly essence. Then and now, physical violence and social sanctions were the lot of such gender rebels. Not only men opposed women's fights for the vote or now the fight to be elected. It is women's objections that have been the most challenging and politically damaging to such causes. What hasn't been claimed by female opponents to women's rights to vote in the United States? That the cynicism and cold calculation necessary for participation in politics would corrupt maternal ability and female altruism. That voting rights would be accompanied by undesirable obligations for women, which they would not be able to meet, such as jury duty. That civil equality would thwart laws which protect women, and that only a minority of women want the right to vote and wish to compel the majority. In 1911, Josephine Jewel Dodge argued that if women were smart enough to choose how to vote, they must also be respected with their wisdom when they oppose the right to vote. And here in Israel, aside from rabbinic threats that children of activists would be expelled from schools or that they are schizophrenic in need of psychiatric treatment, an ultra-Orthodox woman, as Esti Reader quotes in a book in Hebrew on the issue, published an opinion piece asking, how far does your madness go? A few weeks ago, during a 9-hour hearing by the High Court of Justice in a petition against sex segregation in academic programs for the ultra-Orthodox, claiming that it is unconstitutional. For full disclosure, I initiated and am leading this petition for the past 6 years. A brief submitted by ultra-Orthodox and Zionist Orthodox women was presented to the court, claiming that the argument that sex segregation is discriminatory, quote, is drawn from radical and controversial theories such as postmodernism and queer theory. Judaism's support of sex segregation, they argued, is grounded in universally noble values, namely modesty and family. Ironically, it is the very insistence that the sexes are fundamentally different that yields fascinating moments in which the fragility of sex division is exposed and the importance of performance of gender for keeping the gendered order apart becomes highlighted. For example, in New Jersey, women were granted the right to vote even before the 19th Amendment, but men thwarted this by wearing dresses in attempting to vote twice. In another example, in the trial of Susan B. Anthony, who was charged with a felony for having participated in an 1873 New York vote, the prosecuted was required, among other things, to prove that she was a woman, to declare that she dressed as a woman and that she looked feminine. Even after the 19th Amendment, women were required to present at the polls as normative women. Sometimes a woman was denied the right to vote because she did not bear her husband's surname. For many years here in Israel, female ultra-Orthodox journalists were forced to publish their articles in the ultra-Orthodox press using male pseudonyms. Recently, at the Western Wall, a transgender man was sent to the women's section because, according to the guard, there were only two sexes, either male or female. Still today, women journalists at the Western Wall are routinely moved to the back when covering news events such as the visit of the Vice President Mike Pence. Our culture suffers from what you might call a shortage of affirmative models of women who express and insist on their will and desires without being sanctioned or reminded that they should prioritize the needs and wishes of others. For example, in sexual offenses, as legal scholar Robin West observes, both law and culture are content with women's consent, even faint consent, regardless of her desires. Similarly, the neoliberal discourse shifts the responsibility for wage disparities to women, claiming that they simply do not demand higher wages. This despite research indicating that women who do demand increases are sanctioned because they're perceived as too ambitious or as not knowing their place. Just recently, it was reported that women who have personal contracts in Israel's civil service earn 50% less than men. Not only are women required to be considered and prioritize others, but they are also repeatedly asked to wait. Even proponents in principle of women's rights pressure them to be wise and realize that more important or urgent needs should take precedent at this time. This argument was, of course, used against the suffragettes who combined their struggle for the right to vote with that of Black suffrage. Whether to wait or insist on justice to both groups led to a split within the women's movement. There were those like Lucy Stone who believed that it was indeed wise to give priority to the struggle of Black men and wait because the time was not right to get support for the abolition of both race and sex discrimination. Lucretia Mott, Elizabeth Cady Stanton, and Susan B. Anthony rejected this approach and insisted on combining the call for the right to vote for both Blacks and women. And here in Israel, historian Professor Margalit Shiloh's book, entitled in English, Girls of Liberty, The Struggle for Suffrage in Mandatory Palestine, is abundant with quotations from women's diaries and letters in which they wonder whether they were being unreasonable, possibly obstructing the success of the Zionist project, and whether they should perhaps wait their turn. Today, ultra-Orthodox women who fight for the right to run for election on ultra-Orthodox lists contend with a similar demand to prioritize the needs of their communities and refrain from weakening their political power by causing a rift around the contentious issue of women's political leadership. It would be helpful here to pause and contextualize the relationship between sex discrimination and race discrimination in the US and Israel. The histories of the two societies and their legal systems shaped it so that race is the paradigm through which America thinks about group justice, oppression, and inequality. In Israel, it is sex that is the axis through which those issues are developed. The fact that the US Constitution granted Blacks the right to vote 50 years before it gave it to women is but one example. The US courts apply a higher standards of review, strict scrutiny, in examining race-based distinctions than against sex-based distinctions, which only require demonstrating rational basis. The legal doctrines, ethical arguments, and political strategies used to eradicate racial discrimination paved the way to contend with biases against other groups, including women. In Israel, the 1998 Equal Opportunity Employment Law originally prohibited only sex discrimination, and only later amendments added other suspect classifications such as nationality, religion, ethnicity, or sexual orientation. Similarly, affirmative action laws initially focused solely on the advancement of women and were only later applied to other groups. The majority of the case law developing anti-discrimination law in Israel revolved around sex-based discrimination. Now, I'm emphasizing this point for two reasons. First, even though we have not yet achieved equality for women in Israel, our task is to unite the battles and to fight for equal civil rights for all, whether religious or secular, male or female, Arab Israeli citizens and Palestinians in the territories. When Frederick Douglass changed his original stance, holding that women and Blacks should attain the right to vote together, he suggested an assessment of those whose suffering was greater. And he argued, I quote, "When women, because they were women, are hunted down through the cities of New York and New Orleans, when they are dragged from their houses and hung upon lampposts, when their children are torn from their arms and their brains dashed out upon the pavements, when they are objects of insult and outrage at every turn, when their children are not allowed to enter schools, then they will have an urgency to obtain the ballot equal to our own," end quote. We're all familiar with similar contemporary arguments over what is more crucial and whose condition is more dire. We're not doing a good enough job, I think, in finding a holistic and inclusive way to unite the causes. Now, the second reason I discussed the difference between sex and race in the two cultures and legal system is that although sex is the paradigm for working against discrimination in Israeli law, we still have entire areas of the law in which sex discrimination passes as legitimate or at least tolerable, sometimes in ways that it would not be tolerated were it to be on the basis of religion or nationality. For example, the state expends many more resources, both material and symbolic, to preventing terror attacks, that is, harms to Israelis on the basis of their being Israelis, or they being Israelis, then it dedicates to the prevention of femicide, the murder of women simply because they're women, the rate of which is no less and has recently risen higher than that of terror casualties. The monopoly of religious law on personal status is another stark example. We in Israel have become somewhat numbed to the outstanding fact that personal status of women is subject to courts comprising of only male judges in a patriarchal legal system. During her trial that I mentioned before, Susan B. Anthony asserted that she was being tried in a court of male judges and jurors by laws created by men. In matters of marriage and divorce, we're still there in Israel. Similarly, most members of the Israeli public think sex segregation in public spaces is not as problematic as racial segregation, and that even if it were, this is a matter of cultural autonomy to be determined internally by religious communities. So where do we go from here? Two introductory remarks. First, as I said before, I have no doubt that just as women's right to vote feels today like a given, a non-issue even within the religious value set, this will eventually be the case for women's right to be elected to any party at the state or municipal level. Second, it is important to distinguish between a formal right and its actual exercise. Women's formal right to vote, and in most cases also to be elected, is far from addressing the complex and persistent mechanisms that obstruct their representation and participation in parliaments, government ministries, or in national teams managing, for example, the response to the COVID-19 crisis. But these challenges merit separate discussion. So how do we move forward? The solution cannot rest on law alone. Law is in a constant dialogue and influence with social standpoints and conventions. Ultra-Orthodox women's efforts for political participation cannot remain theirs alone. Historian Robin Muncie emphasizes that without the efforts of women in states who granted women the right to vote prior to the ratification of the 19th Amendment, the amendment would not have been enacted. The state of Wyoming asked to join the Federation of the United States at the end of the 19th century, but Congress objected to the request because the women of Wyoming had the right to vote. Wyoming responded to Congress with a short telegram worded, according to some testimonies, "We will remain out of the Union 100 years rather than come in without the women." For us, the women and men who hold the right to run and be elected in parties to represent our communities, the right of an ultra-Orthodox woman to participate should be a high priority on the list of political demands. Every politician in Israel today must be fully aware that the political process in which they are participating is tainted with illegitimacy as long as there are parties that categorically disqualify women. It is also vital to understand that this issue pertains not only to ultra-Orthodox women, it affects every woman's political participation. For example, about a year ago, the Knesset accommodated the request of a Shas Knesset member to move a female Likud Knesset member from her assigned seat in the Knesset theater so that he would not have to sit next to a woman. Female MKs wearing respectful, though sleeveless garments are scolded. In the April 2019 elections, when the Rebbe of Gur arrived at the voting booth, members of his entourage expelled the female supervisor, explaining that he did not come into contact with women. Just earlier this month, meeting with MKs from Agudas Israel, the Rebbe of Vizhnitz said, "I was surprised to hear that you recklessly sit and speak to female MKs," adding, "Do not forget that you were sent to do holy work by myriads of Israel, and you are absolutely not permitted to converse with women." Still, what of the legal front? In 2008, the National Labor Court ruled that an ultra-Orthodox kindergarten teachers organization could not be recognized as a labor union because it has been run solely by men, denying women the right to vote or be elected. This is all the more true in the case of a political party. Israeli law can and should disqualify any political party which categorically excludes women as women from participating in the democratic process. A more moderate option that was also suggested in several cases would be to apply sanctions through party funding. There are other possible legal remedies. Solutions exist, but they require commitment that stems from the recognition of the enormity and severity of the injustice. In the present climate, resolutely deciding to provide a remedy that would actually enable ultra-Orthodox women the right to be elected in their communities also requires political and public courage. Perhaps ultimately, we in Israel should work to promote our own version of the American Equal Rights Amendment. Thank you.